welcome to Gracefully Graying. I am your host, Attorney Henry Gornbein. Today on Gracefully Graying, I am pleased to welcome as my guest Lisa Zastrow, who is a partner from the Las Vegas, Nevada office of Lipson Neilson, as we discuss some sensitive workplace issues. And let me remind you to watch this video on our YouTube channel and also go to and like gracefullygraying.com, our website. Lisa, tell us about your background.
Sure. Thanks for having me on your show. I am an attorney currently living and working in Las Vegas. I'm originally from Oklahoma. I was born and raised in Oklahoma and went to law school in Oklahoma. I was raised primarily in a small town on a farm with my mother, who was a teacher, and my stepdad, who's a farmer. And my father's a physician in Oklahoma. And my stepmom retired early. And when I was 27, I met my husband, who was in the Air Force, and he stole me away from Oklahoma. And I've been a military wife and attorney for 20 years. And we ended up in Las Vegas because my husband was stationed out here first at Nellis Air Force Base and then Creech Air Force Base. And my legal career started off as kind of a trial attorney litigator in Oklahoma. And most recently, now I've focused my career in defending professionals.
So you mean defending professionals, you're talking about what, legal and medical malpractice defense, basically?
Essentially, I get asked a lot what I do, and that's kind of the most simple answer, is to say I defend professionals. We do, when I say we, I mean our team at Lipson Neilson. My primary practice is defending attorneys and also employment law, defending employers, defending brokers, accountants. I do defend doctors and dentists. So I kind of discovered that passion about 5 years ago after being involved in some situations where some attorneys had fallen on some hard times and needed help with their practice. And since that time, I joined Lipson Neilson.
Lisa, how did you come up with the topic, straight talk with a lawyer who isn't afraid to straight talk?
I came up with that topic because people tell me all the time that I am a straight shooter, and I tell it like it is. So I find in the legal profession or community, a lot of times attorneys will not provide black and white answers or even discuss some of the nuance. And over the years, my friends, families, colleagues, they all have similar questions when it comes to employment law. And unlike some areas of the law, for example, wills and estates, we know that there's a linear process to setting up an estate plan, or we know there's a linear process to filing your tax returns. But when it comes to employment law, people are confused. They want to keep their jobs. So I'm asked questions of employers, who we primarily defend, and I'm asked questions of employees, my friends, my family, and I have to often tell them there are many aspects to employment law, not just the law. You know, we have the law as guidance, but there's also the element of what's the best course of action depending on what's going on. So
can your employer ask your age?
For sure, there's no prohibition on asking an employee their age as a matter of law. However, there is a prohibition against discrimination in the workplace, age discrimination. So there may be a scenario when an employer could ask your age if your age relates to the job. For example, if you're a bartender or you're applying to be a bartender and you have to be 21, the employer can ask you your age. But This comes up often after an employee's already been working for the employer for many years. And the scenario is, is my employer discriminating against me because of my age? So can an employer ask? It's not strictly prohibited. If they do ask, it depends on the context and whether or not that may result in discrimination.
Lisa, what should you respond if you are asked that question by an employer?
It depends. And it depends on the scenario. I mean, I'm, like I said, I'm from Oklahoma, and, people are very open, and you're chatting with your employer and you discover you're from similar hometowns, and they ask you, what year did you graduate? That's an innocent question. It's not designed to discriminate or harass. So it depends on the context. But obviously, if your employer is trying to determine your age, and it's clear, you can use your God-given intuition that maybe they're looking to determine how much longer you're going to be with the company. There's all kinds of scenarios. So if your employer is trying to determine your age, and you get the sense that it's for an illegal purpose, maybe the discrimination is going to be coming down the pike, or maybe you see that your replacement's already been hired before you've been fired, then you have options. You
Right.
can, and I actually have that situation right now. I have a colleague whose replacement has been hired, and I'm working with her right now. Age discrimination is illegal for employers with more than 20 employees. So what do? If you feel that it's a violation of your rights, you can report it to your state EEOC office. And they investigate. And if you you can take it to the next level. If you get what's called a right to sue letter. But in employment law, one thing that's often misunderstood is that nearly every scenario, unless you have an employment contract, nearly every scenario requires that you first go through an administrative process. You can't just go sue your employer. You have to file a claim with your local EEOC or NERC office. But I get to ask that a lot, and I ask them, what are your goals? Do you want to keep your job? Do you want to try to transition out? And I try to give some practical advice.
Lisa, can your employer terminate you without cause?
Absolutely, if you don't have an employment contract. So much of what I'm talking about is just, I'm not talking about, there are many types of jobs, right? Government jobs, and then the private sector. And private and government jobs operate quite differently. And even in the private sector, large employers, and I'm in Vegas. So for example, we have a culinary union. So larger groups of employees have union agreements. So depends on your scenario. Are you a member of a union? Do you have an employment contract? If you don't, and you are an employee at will, which is what we have here in Nevada and also in Michigan, our Lipson Neilson office is primarily in Michigan. An employer can terminate you without any cause. They cannot, however, terminate you for an illegal cause, which can be very confusing. My employer can come into my office today because I don't have a contract and terminate me. But if I find out that they terminated me because I'm 46, which is a protected class under the Age Discrimination Act, then I have a cause of action because they didn't terminate me without cause. They terminated me for an illegal cause. And that can give rise to a claim for discrimination against me at my ripe old age of 46. Because a lot of people are surprised to learn that age discrimination begins at the age of 40. Every man and woman is protected over the age of 40, which is young, right?
Very young from my perspective.
Yes. So I
That's,
don't know if that answered your question.
no,
An employer can do whatever they want. The question is it illegal? And if it's illegal, what are you going to do about it? Are you
right.
going to gracefully bow out and try to, or are you going to file a complaint? You have many options. Most people call me and I try to negotiate a severance.
Lisa, can you have a romantic relationship with a coworker in your office?
In my office, sure. Although my husband might be upset.
He might not be happy about it.
But there is no, in my office, we have no policies and procedures. So the other thing that always comes up in employment law is it a government job? Is it a union job? Do you have a contract? If none of those things, then you look at your employee handbook. And that is the rules of your office. And I have worked in, for example, law firms where we had a no fraternization policy, meaning I couldn't, if I were single, I could not date a colleague. So you first look to the policy. The other situation, most attorneys will tell employers absolutely not, strictly prohibited, don't allow it in the workplace, it's a distraction. But we're all human. Many people meet their spouses and significant others at work. So you can have a relationship in the workplace if it's not prohibited. It is ill-advisable and could possibly lead to sexual harassment if you are a superior and you are in a relationship with a subordinate. That turns south frequently. And in the day and age of social media, text messages, employers, what happens is you have a superior dating a subordinate and it goes south, and then the subordinate claims sexual harassment. So that is why a lot of employers prohibit dating in the workplace. It's not illegal as a matter of law, but if your employer has a rule against it, you can be terminated.
Well, even without a rule against it, it sounds like it could be a minefield.
It's a minefield. It's a total minefield. I wouldn't do it. First of all, I could never date a lawyer. And I've been married for 20 years. But I think it's insane, but I know people that in our office, actually, we have attorneys that are married and working in our office. Seems insane to me, but it's a minefield. It works for some, but sexual harassment, I mean, the list goes on and on of the problems. And that's why an attorney will say, don't do it.
Lisa, what should you do when you find out that your coworker who has less experience makes more money than you?
Well, that happens all the time. In law firms, and I speak to law firms because that's my experience, but obviously there are jobs all over, right? Restaurants. The job market ranges, obviously. But most employers adhere to fair labor standard practice, equal pay. It's been around for 50 years. But inevitably, in professional environments where pay fluctuates, you're going to have a scenario where you may find out that somebody's making more money than you. And it depends on the situation. It's not black and white. I, as an attorney, may find out that my younger male counterpart makes more money than me. Maybe he works more hours than me. Maybe he brings in more money than me. It just depends. So first you have to figure out, how did you find out that information, and was it confidential? And if you have confidential information about salary, that's a problem. But you have the right under the law to address that issue with your, if you work in a big enough office, more than 20 people, to address that issue with your HR. Now, as a practical matter, if you do that, you should be very cautious about it, because you don't always know the facts. I see a lot of this, you don't know what that other person is doing. So your first option would be to go internally to your own management and ask for a raise. Maybe not even mention what you know about the other person, but what do I bring to the table? I would like a raise. Discuss it. Take personal responsibility for your own life and your own salary. If that doesn't work and you find out there is something illegal and harassing going on, first of all, I wouldn't want to be working for that employer. I would be planning my exit strategy. But if you, your options are to file a wage claim with the Labor Commission in Nevada. So again, many options, but it depends on what your goals are. I'm the type of personality, if that were to happen to me, I would evaluate my own worth and my own value, and I would ask for a raise. I'm probably overpaid, actually. No, I'm kidding.
We're on camera. Be careful what you say.
I know. I'm kidding. No.
Lisa, what if you find out that women in your office are paid less than their male counterparts for equal work?
So I can joke about my office because I work for the best firm in the nation, as you know, and that doesn't happen in my office. But that has happened in other firms and in other places of employment. Equal pay for equal work has become almost a political topic. But in Nevada and nationwide, there is a Fair Labor Standards Act that requires equal pay for equal work, and it protects men and women. You specifically asked women, but it protects men and women. But again, you have to evaluate the type of job. And if you find out that, again, somebody is making more money than you for the same work, you need to ask for a raise. There may be an innocent reason for that, especially in large companies. People are brought on at different times, and they, somebody hired 10 years ago may be on a different salary pace than somebody brought in now. And there may be an innocent mistake. Don't automatically assume that your employer is some oppressive entity that just wants to keep you down. That's not my experience. That's not my experience at all. My experience is that employers want to keep good people, and the last thing they want is disparity, discrimination. They want their employees to be happy so that they produce good work and stay. So don't assume your employer is trying to screw you over. Discuss it, and then again, that you always have the option. An employee always have the option, if you're in a business with more than 20 people, to file a complaint with the EEOC for discrimination, or the Labor Commission, or the agency that controls wage and hour.
And are these entities responsive? It seems like there's a drastic change going on where women are being recognized and being paid equally, but then you've got the issue, Hollywood's a prime example, where for years, female actors have been paid far less than their male counterparts. Or you have the NCAA, which has clearly treated the male athletes very different from the female athletes, as indicated by the recent March Madness basketball tournament. So you got a lot going on there. Any comments on what I'm saying?
Well, I could make a lot of comments on what you're saying, but I have a lot of opinions about all of those issues, and you raise different scenarios, different employment scenarios, for example. When you're talking about professional sports, my opinion on equal pay comes down to what's bringing in the revenue. And in terms of Hollywood, I depends on who's bringing in the money. Tom Cruise is likely going to make more money than me as a walk-on. So I am not someone who looks at the issue of equal pay by combining every job in the world and doing the math. Every job is different. Every labor source is different. I'm not a professional athlete. I am sure that if I was a female basketball player, I would want to be earning the same as LeBron James. But actually, that's not true. I'm more practical than that. They just, it's brass tacks. So, I look at it from a dollars and cents, and I don't think that it is necessarily a gender discrimination or an age discrimination. There are female-dominated jobs. Teachers. Well, unfortunately, teachers don't make a ton of money. Maybe we should look at raising education salaries.
We should.
Traditionally, RNs, more females. There are many females that have managed to earn as much or more than their male counterparts. But I don't think that you can compare the NBA to Walmart, or the NBA or the NFL to Lipson Neilson. There are different labor forces. And I don't look at things that way. I look at things mathematically, linear. And you have to, a lot of people will find discrimination or, oppression just because it's the hot topic. But I don't look at things that way.
Lisa, what would you do, or what should you do if you find out that your coworker has been promoted ahead of you?
Well, again, it depends. As a female, that can happen, and that's a different scenario than the NFL and the NBA, right?
Right.
That's athletic ability. When you're talking about, let's say, an accounting firm or a law firm, you have two individuals that do the same work, do the same, put out the same productivity, and one's promoted over the other. Why? If it looks like a duck, walks like a duck, quacks like a duck, it's a duck. And I've had this happen to me, actually. Attorneys promoted to partner over me when for no reason, right? Because I'm perfect, and why? But
Well, for years,
that
Lisa,
happens,
for years, Lisa, that was very, very common in the law firm workforce.
yeah,
Women were not promoted, were not made partners. So
yes, but law firms could identify reasons for that, and I'm not saying they're right, but women, tend to take off 12 weeks when they have children, for example. I'm not saying that that's right or just, and that's changed. That's changed a lot. Now most firms have initiatives, especially large global firms, to promote within females, minorities, older individuals, because they want to be perceived as fair. So, the world is changing, and I don't know that I'm willing to say that every employer in 1975 was, or 1985 or 95, had discriminatory and hateful intent. I think a lot of times, people looked at brass tacks, but now we are a nation more aware of equality for women, people over 40, minorities. And so when that did happen, you asked me what would happen. I'll tell you what happened. What I did, I went into the managing partner's office and had a discussion about it. And I was given guidelines for what I could do myself, and essentially told to take personal responsibility for the fact that I wasn't promoted to partner that year. I did do that. I took personal responsibility. I was promoted to partner the next year. And then I planned my exit strategy, because that firm is a horrible firm that rewards bad behavior. And now I work for a better firm. We do better work, and we're taking all their clients.
So clearly,
my point is, there's a fine line between personal responsibility.
you've gotten the last laugh, apparently.
Yeah, I did. Still am.
We've got about a minute left. Would you provide our viewers with some 5 bullet points, kind of summarizing what we're talking about, where we're going in this important area of really, the legal environment and what to say or not to say?
Well, so 5 bullet points. First of all, there's so much information on the web. Do not feel handicapped. Get online, Google age discrimination. If you feel that something's happening, you have so much information. You can Google the EEOC. You can Google the Fair Labor Standards Act. You can Google common sense words, age discrimination. So you have information at your fingertips. Now, don't use your work computer when you do that. And then the second thing is, don't automatically assume that as I said a minute ago, don't automatically assume that your employer doesn't care about you or doesn't want you around. That's not my experience. I defend employers. My experience is that people are human, and things occur in the workplace. So give your employer a chance to fix a problem if you've identified one. Give them a chance. And then if it's not for you, plan your exit strategy. If you need to hire an attorney, nearly all attorneys in the United States defend employees on what's called a contingency fee basis, meaning you don't pay anything to retain an attorney until and if they recover. So in terms of having access to justice, employees often do. Now, employers don't like that, but I think it's important in America that citizens be able to have access to justice. And people think they can't have lawyers, and that's just not true. So utilize your information on the web, utilize your friends, give your employer the benefit of the doubt, make a record, and
Great.
always.
We're out of time. Lisa Zastrow of Lipson Neilson, I want to thank you so much for being our guest on Gracefully Graying this morning. I also want to encourage our viewers to watch this video and other videos on our YouTube channel, and also go to Gracefully Graying, our website, and see all of the wonderful information that we have, and please like it and share it. Lisa, thank you so much for being our guest.
Have a great day. Thank you.